It's always fun to be the first speaker. I appreciate everyone in this room for your commitment to your communities across the state, for your leadership, for being here today. I see my home county mayor, Mayor Ellenbaugh over there, and city attorney. Wake up, Tim. Tim Meitzen, a city attorney at Batesville, and I have been friends for a number of years. It's good to see you, Tim. Again, I thank everyone in this room for your commitment to your communities. You truly are on the front lines of service, working every day, working on issues with a number of employees, providing services, dealing with complaints about trash, perhaps law enforcement, code enforcement about employees, you name it, code enforcement about trash. All of your issues range, and I know that you've heard them all, and I know that people don't call and say thank you enough. So thank you to each and every one of you all for your work to your communities. As Mayor Brown mentioned in my bio, I believe in face-to-face conversations because they truly do lead to real solutions. And many of you all have experienced that as I have traveled across the state hosting roundtable meetings. These roundtable meetings are an opportunity for me to hear from you all and the leaders in your community about what's going on, how we can make it better. Last year I traveled all 75 counties, 30,000 miles talking to individuals, hearing from you all about issues. Now I started these roundtable meetings based on a lesson that I learned in college. It wasn't when I was sitting in the classroom at the University of Arkansas, but rather when I was back home in Independence County in the summers. I flagged traffic for the highway department. And during that time of flagging traffic, I saw that sometimes there could be a disconnect between the men and women out on the road and the folks in the office. And so I want to make sure as Attorney General that there's not that same disconnect between those of us who happen to work in the capital city in Little Rock and the communities across the state that we serve. We've also launched mobile offices coming to each and every county across Arkansas. It's the first time in the history of the Attorney General's office that we've held office hours in every county. Because I don't believe that someone ought to have to drive from Jasper or from Eudora to downtown Little Rock in order to have a face-to-face conversation and to get the help that they need. These mobile offices, we provide information about identity theft scams. I know that you all in your offices have people call all the time, or they call the police department or someone and say, I've got this phone call from the IRS. Well, the IRS is never going to call you. But unfortunately, people that we care about in our communities fall for those scams. And so we need your help to continue to educate people about these sort of scams and cons. So please sign up for those consumer alerts. Help the people in your community to protect them. Prescription drug take back. I'd venture to say everyone in this room knows that we have a prescription drug epidemic in our state, and it's in your communities. We work with local law enforcement, either the police departments or the sheriff's departments at our mobile offices to get prescription drugs out of the cabinets away from loved ones. Please continue to work with your police chiefs to make sure that they have a take back, because we must clean out our medicine cabinets and get those painkillers and opioids out of the hands of those who are addicted and don't need them. With regard to public safety, as the state's chief law enforcement officer, I couldn't be more proud of our law enforcement and the partnerships that we have with your communities on public safety. With regard to public safety, Dawn did ask me to talk about Attorney General opinion on open carry in Act 746. Those of you all who have been to the roundtables have heard me talk about it. But I'm going to break it down very easy for you, and I do encourage you all to go to the AG's website and to read that opinion. It's 17 pages, which can be daunting, I understand, but we try to write it in language so everyone can understand that you don't need a legal degree. If you can't tell already, I don't use a lot of 50-cent words when I speak. And I believe that's Arkansans, when there's confusion in the law, they need to be able to understand the law. Act 746. The opinion simply says that an individual may carry a firearm openly as long as he or she does so without the intent to unlawfully attempt to employ it against another person. 4 very important caveats to that. First caveat, if you are openly carrying, which I do not encourage, but should you decide to openly carry, expect that law enforcement may approach you, so that way law enforcement may determine whether or not the individual has that intent to unlawfully employ it against someone. Second caveat, all other state laws, statute with regard to handguns, firearms are still in place. For example, you may not carry a firearm into a publicly owned building or facility. We use the state capitol as the example in the opinion, but it could be the municipal building, it could be the county courthouse, any publicly owned building or facility. Third caveat, that a private property owner, a private business owner, does not have to allow firearms into his or her business. Maybe the local auto parts store. They could have a sign up that says no guns, or a gun with a strike through. That's fine. They don't even have to have that sign. Someone walks in, she's got her Glock on her hip. Manager says, "Ma'am, I'm sorry, no Glocks allowed in here, no guns allowed in here." Once the individual stays past that point, then it could rise to the level of criminal trespass. And so private property owners, private business owners do not have to allow firearms. And then the fourth caveat is quite simply, if you wish to conceal and carry a firearm, you must first obtain a conceal and carry license. Again, I do not advocate for open carry. If you want to, I encourage people to talk to your legislators about this law and any other law that is confusing. But it's important for all of us to be on the same page and to ensure that our Kansans know what the law is and that we write it clearly and fairly and accurately. As to law enforcement, first let me just say I appreciate the Municipal League and printing the Attorney General opinions in city and town. It is so helpful. Please, all those opinions are online. Make sure that if you have an issue or request, in addition to open carry opinion, we certainly have recently issued opinions from the office about short-term municipal financing, restrictions on municipalities' expenditure of public funds. So please come to arkansasag.gov and look at those opinions if you have not done so already. In addition to talking about Act 746 and open carry with regard to public safety, we have done a number of things at the Attorney General's office to affect public safety that you all may not be aware of. Right after I took office a year and a half ago, one of the first things I did was distribute over $14 million back to the General Treasury to be used just for public safety, to be used to alleviate the jail overcrowding. We designated $500,000 to the Department of Rural Services to go toward volunteer fire departments. In a short period of time, and I've announced that we are distributing $1 million to go toward AWIN to make sure that we have the safety measures in place that all law enforcement, public safety, first responders can contact one another. We've launched a Medicaid, not launched a Medicaid, but we have our Medicaid fraud. We've launched Social Security disability fraud, but we also have a cyber crimes unit at the Attorney General's office. We cannot do enough training to teach adults how to get smart and how to keep their young ones safe online. Please attend one of our seminars, talk to young people, learn how to use the internet, learn how to use smartphones. Help us protect the young people in your lives. As the Chief Law Enforcement Officer, I wrote an op-ed that was published nationally about the role of law enforcement in our communities. And I know as mayors and leaders in your towns that you know the value of law enforcement. You see the sacrifices of the men and women in blue. But unfortunately, we're at a time where we've heard too much criticism about the men and women in blue who keep our communities safe. And so when you hear that sort of criticism or see it on Facebook or Twitter, here's my simple ask to you, friends. Shut it down. shut it down. Our law enforcement, they keep our communities safe. When someone looks to move to Hot Springs, Texarkana, Jonesboro, Pocahontas, they ask 2 questions. Are the schools good? And what's the crime rate? So we must keep our crime rates low. We must keep our communities safe. Let's encourage our law enforcement. I appreciate the role that you all do every day. I appreciate your leadership. Please continue to attend the roundtables. Call me, contact me, email me. I'm the only Leslie at the office. I'm pretty easy to find. Thank you all so much. God bless each and every one of you all, and God bless Arkansas. Thank you. Thank you, Mayor. Thank you. Unfortunately, I've got to run, but I appreciate you.
We had to protect ourselves some way, and we put in some types of protections. We have caps on the millage for local government services. We have caps for certain entities. You can only assess a mill for a police pension or a fire pension or a non-uniform employee pension. You can have only certain caps on libraries. And these are the types of things that help us. The other 2 steps that we typically have is that bonded indebtedness usually has to have an election behind it before it's imposed. If it's something, or if a tax is imposed by the legislature, they're supposed to have a supermajority vote to be able to do that. So that was what was done. The problem was it wasn't done in 1836. When Reconstruction came, we had people down here running the government who really had no interest in Arkansas. They undertook a great deal of indebtedness that they left us with in 1874 when they left. And then on the railroad situation, we had a lot of towns that were building parts of railroads, figuring that if they put the station there and they put some tracks there, then the Intercontinental Railway would come there. And for the towns where it actually came, that wasn't a bad thing. For the rest of the towns, there were no revenues to pay off those bonds. And as a result of that, not only in Arkansas were bonds defaulted upon, but throughout the country. And if you look at the state constitutions that go along the trail of the initial Intercontinental Railway, you all have a provision, something like our Article 12, Section 5. Cities are not supposed to be getting involved in economic development bonds because cities do not really have the ability to control their finances as well as the corporation. We can't charge $1 more for a shirt next year. We can't refuse to deal with a catastrophe in one year with flooding or something of that nature and use up whatever reserves we have. Unfortunately, those 3 things, the railroads and millages, led to this. Now, the decision that we had in the Little Rock case, which is on appeal, threw all of this into some kind of a question as to whether we can deal with economic development entities such as the chambers. And so this issue has been developed that would allow a specific amendment to Article 12, Section 5 to specifically allow for contracts for economic development, which could include funding and bonds. And I think the only thing I'm really here to say today is it opens wonderful opportunities for local governments. The chambers have worked with the league to make sure that there is statutory language that is going to be introduced at the next General Assembly and supported, and our hope is that it will get in unscathed because it's got safeguards and protections in there. But my comment today is simply this. Things haven't changed since 1836. If it sounds too good to be true, it probably is. Fortunately, we have a long history in Arkansas of people being very, very protective and conservative with the use of public funds. But we've got pressures upon us as local governments that we've never had before. We're having to digitize our activities. We're having to provide services we've never provided before. And we're having to compete for businesses that we never thought would want to come to our places before. So all I'm going to leave you with today is this history of this constitutional provision is there for a reason. And it's always going to be incumbent upon you as city leaders to say, it sounds too good to be true, because it is. Thank you.
Thank you, Attorney Carpenter. This time, we will have Kristen Huggins of the University of Arkansas Cooperative Extension Service, and she will brief us on some ballot proposals. Ms. Huggins.
Thank you. Thank you for having us here. Good morning. So my colleague, Dr. Stacy McCullough, spoke to you all at your winter meeting, and she went over some of the ballot issues. So a lot has changed since that time. Deadlines have passed. We have a little bit better idea of what might end up on the ballot, but there are still some important deadlines to come. Different groups out there collecting signatures have until July 8th to collect and turn in their petitions. So I offer you this information with a caveat that we are still researching these issues. We're still talking with ballot issue groups. We haven't finalized our information. So this is kind of an unofficial presentation of the information. You'll get our official version in September, which includes what do all of the issues say, what will appear on the ballot, what does the terminology mean, what are supporters or opponents saying about it. That will all be in our fact sheets that we'll be publishing in September. So I encourage you all to look for those. And speaking of fact sheets, I just wanted to say real quick before I get into the issues that we had individual fact sheets that are placed at our county extension offices across the state, all 75 counties. I'm sure you all are very aware of your local cooperative extension office. And instead of having individual fact sheets on all of the issues, we're going to be combining them this year into a single voter guide that I think will help people picking them up realize that there's more than one issue on the ballot. So just going really quickly, the path to the ballot, as you all are very aware, that the legislature refers issues to the voters, and then there's the ability for citizens to collect signatures. So I'm going to touch real quickly on the issues from the legislature that we've known about for a while. Some of you all might be familiar with them. Some of you might be hearing about the details for the first time. Now, this is a pretty big issue out there in the counties. Issue 1, this would allow 4-year terms for certain elected county officials. So all of your county officials that you vote for on the ballot, except for justices of the peace and constables. So the administrative side of the county, they would go from 2 years to 4-year terms if this was approved. It would prohibit elected county officials from being appointed or elected to a civil office, including the JPs. It would allow people who are running for office unopposed to be elected without their names on the ballot. So that way you wouldn't see that long list of people's unopposed names anymore. And it would define what infamous crime means in the Constitution. There is a state law that has some definitions to what it means, but this would put it in the Constitution, and it would include felonies, abuse of office, tampering, and then some very specific misdemeanors that you see there: deceit, fraud, and election crimes. So issue 2, this is probably the more simple one on the ballot. This one says that we change the Constitution to allow the governor to retain power and authority when leaving the state. So half of the states in the U.S. have a provision that lets the governor keep their powers when they're out of state, and then the other half is kind of like Arkansas right now, where the authority shifts to somebody when the governor leaves the state. And how often this is an issue depends on who's governor at the time, the issues of the day. For example, I think our governor was in New York earlier this week, so it just really depends on what's going on. And the lieutenant governor would no longer assume authority when the governor leaves, if this one's approved. And then issue 3, which Tom touched on briefly, there's a lot packed into this. I encourage you all to, if you haven't already, to read the legislation and to read our fact sheets on this when they come out. He mentioned that it would amend Article 12 to allow counties and cities to obtain appropriate money for corporations, associations, institutions, or individuals. And look here, it says to finance economic development projects and provide economic development services. You'll see those terms used throughout the document for issue 3, and I put these handy little definitions here for you so you can see how wide a scope economic development project means. There's some of this already in other parts of the Constitution, but it applies it to this area if passed. You see all those different land, building, infrastructure, and then it talks about these specific businesses that would qualify for these bonds. And I really, again, wanted to give you all an idea or a scope of the definition. One word can mean so many different things when we're looking at the Constitution. So infrastructure, it could mean anything between land acquisition to railroads, railroad spurs, construction, employee training, even environmental mitigation and reclamation. And when we're talking about economic development services, again, another phrase that's used throughout issue 3, it means all these different things: planning, marketing, strategic advice, supervision of industrial parks, negotiation of contracts. So all of this falls within the word economic development services. And although voters are going to be voting on this, it includes in there a clause that the legislature can amend this with 3/4 a vote in each house. I did tell you that issue 3 was packed full of stuff, didn't I? So there's a little bit more. It would also amend Amendment 82. So it would remove that constitutional cap on how much in bonds that the state can issue for economic development projects. Right now, it's a 5% cap, or 5% of what the state general revenues were for the previous year. And so that right now is about $317 million. It would amend Amendment 62. This is where it gets a little bit more personal for local governments, because this is the local capital improvement bond section of the Constitution. It replaces industrial development with economic development. So think previously to those slides that had all of those different areas where bonds could support. It talks about this in the section where counties and cities, how much bond debt that they can take. It would allow the General Assembly or a legislative body at the local level to use other taxes beyond special taxes to retire bonds. It repeals a requirement that bonds be sold only at public sale. And then it removes an exception for special tax revenues if there's anything in excess that previously you could use that excess toward a new bond if approved by voters. It would delete that section. And again, all throughout the document, it replaces industrial with economic development, especially in the section talking about how local governments can work together. Again, that's something that the legislature can change the definitions with 3/4 a vote in each house. Just the reason why I bring that up is not every constitutional amendment has that clause in there. So those are the 3 that you've probably heard a lot about, been aware of, and so I'm moving on now to the local issues or the initiatives that require people to canvass the state and collect signatures. If any of you have been at the zoo lately or out, even filling up your gas tank or at a festival, you've probably seen some volunteers or some paid canvassers coming out asking if you're a registered voter and asking for you to sign their petition. When Dr. McCullough was here, there was a whole different slate of potential issues. I mentioned a lot has changed. A significant deadline passed, so now we know who the serious people are as far as which groups are working to turn in signatures to the Secretary of State in July. So right now there are 6 groups working, 6 different groups. Let's see, 5 constitutional amendments and 1 act. And I'm going to go over these briefly. Again, our fact sheets that we publish in the fall will have a lot more information about what these issues will do and answer some common questions that people might have. So the Arkansas Term Limit Amendment of 2016, this would undo what voters did in 2014 when you all extended the number of years the legislature could be members of the legislature could be there. So it would reduce the total number of years from 16 to 10. It would limit House of Representatives to 3 2-year terms, and then limit Senate to 2 4-year terms. And you could mix that up however you want. You couldn't go past 10, depending on some of the very specific circumstances, such as if you've been elected or you're filling a position or appointed to a position. This next one is one of the newer issues that was recently approved at the Attorney General's office to go out and collect signatures. So there's not been a whole lot out there. It's an amendment to limit attorney contingency fees and non-economic damages in medical lawsuits. So this would change Amendment 80. Excuse me. So in addition to the Supreme Court having the authority and the power to regulate the rules and procedures of the court, it would also empower the General Assembly to pass laws regarding excessive contingency fees in medical injury cases. So, okay, what's an excessive contingency fee? Well, it goes on to define that as a third of what is recovered in a medical injury case. And it prohibits attorneys from charging more than 33 1/3% or excessive contingency fees in these lawsuits. This is another issue that has a lot in it, and again, I recommend that you read the legislation if you have questions about what it will do. It would allow legislators to pass laws governing how value of periodic payments should be calculated, whether life expectancies or other factors should be taken into consideration when discussing damages or awards in a lawsuit, medical lawsuit, what extent of value calculations shall be required, and a penalty for attorneys who do charge more than a third or 33 1/3%. It would also amend Section 32 of Article 5. It would require lawmakers in the next session to set a maximum dollar amount of non-economic damages. And when we talk about non-economic damages, that's pain and suffering. That's beyond what someone might earn or lost income. It's pain and suffering that is a separate award usually given in lawsuits. It would set a maximum of $250,000 for non-economic damages, and then it requires the Supreme Court to update that every 2 years depending on inflation. And it defines throughout there what medical injury means, healthcare professional and business, and then it allows legislators to further define what those terms might mean, or they could at a later time add other definitions. I know I'm going pretty quick on these. So here's another one. These last two were approved within the last month, so there's been a lot of last minute push to collect signatures on these. And so depending on whether you've been on vacation, you may or may not have seen some of this. So this is an amendment that would allow 3 casinos to operate in Arkansas. It would put in the Constitution these 3 companies' ability to operate a casino in these different counties. You see one in Boone County, one in Miller County, and one in Washington County. There's been this issue has come up before, and so it's kind of the same people involved and the same areas involved. It would create the Arkansas Gaming Commission to regulate and oversee casino gaming, and it would establish a casino gaming tax rate of how much these casinos would have to pay in this tax to the state, to the city, to the county. I'm moving on now to medical marijuana. This is probably the issues that most people hear about the most. There are 3 different proposals related to marijuana. 2 of them are specifically for medical marijuana, and I'm going to go over those first. This is the one that is not a constitutional amendment. The Arkansas Medical Cannabis Act is a very long document, a very long proposal that includes specific code and specific directions for the state to follow when it comes to medical marijuana. So both this issue and the next would legalize the growing, distribution, selling, use, possession of marijuana for qualified medical purposes, and there's a definition in there talking about what medical issues would qualify a person for this. It uses the Department of Health to oversee the rules and regs. It would allow patients and caregivers living more than 20 miles from a dispensary to grow their own marijuana. They would have to have a hardship license issued by the Department of Health. It calls for cannabis testing labs that would look at the quality of the marijuana plant. It would look at whether pesticides have been used. It would allow local governments to limit the number of dispensaries, or what they call care centers, and enact zoning laws. And it provides some state protection, not federal, because it would remain illegal under federal law, but provide some state protection to patients, caregivers, employees working in the industry from criminal or civil penalties or discrimination. And this act would say that the tax revenue would offset the Department of Health's expenses, but then it would also go to pay for the cost of low-income residents to access medical marijuana. This next one is an amendment. So it would put it in the Constitution, again, legalize the use, possession, distribution, sale of marijuana for medical purposes. It would also rely on the health department for overseeing patient rules and permits, but this one is a little bit different in that it would have the alcohol beverage control, and it would create a medical marijuana commission to regulate dispensaries and how much can be grown. This amendment is typical of other amendments where it provides some basic language and then leaves it up to state agencies or legislature to kind of flesh it out. Only dispensaries or the cultivation facilities that grow marijuana could grow. There wouldn't be any grow your own at home. It too allows local governments to limit the number of dispensaries and enact some zoning laws, and also provides the state protection for people from criminal or civil penalties and discrimination. The tax revenues under this proposal would offset the cost of the health department's time, the ABC's time, the marijuana or the Medical Marijuana Commission's time, but what's left would be distributed to the general fund and then these other funds that you see there on the screen. And then finally, we have the Arkansas Cannabis Amendment. This is an amendment that would legalize marijuana for all purposes, for medical, for recreational. It doesn't have any, they're not approaching it as a medical issue. They're approaching it as it's a plant, so it should be legalized for any use. It would legalize the growing, distribution, and use of marijuana. It would call for the release from jail of people who have been convicted only of state crimes related to marijuana, release people from probation or parole who've been convicted of, again, state crimes for marijuana or paraphernalia possession. It would allow them to expunge their records for these state crimes. So, for example, if there were multiple other crimes that had nothing to do with marijuana, that would not qualify these people. It establishes a difference between industrial hemp and marijuana based on the percentage of THC in the plant. It would allow people who are 21 and over to grow up to 36 plants. And it would add a 5% excise tax to recreational marijuana that's sold, but not any to medical marijuana. And then it would also allow the sale and possession of paraphernalia, such as pipes or scales or other things that you typically have with that. So that was a very quick review of these issues. And again, I want to remind you all that we'll have information in September on our website, uax.edu/ballot. You can sign up for our newsletter. Everybody received a handout in their bags talking about the different information that we have at the Cooperative Extension Service about the ballot issues, including the fact that you can request one of our county agents to come and provide a presentation on the issues if there's anything at the local level that you want to hear about. So thank you all for your time. And I noticed everyone had like their Twitter or their Facebook in the program, so I added our Twitter page there. So follow us online. Thank you.